Good afternoon, Anastasia. Can you hear me? Hi, Marjorie. Hi, Marjorie. Hi, Anastasia. Can you hear me? Hi, good afternoon, everyone. Can I just check everyone's mics, cameras are working fine? Can you hear me? I'm Maria, Inas, Anastasia. Can you unmute yourself? Maybe turn on your camera and we can just test it.
I can hear you.
Great. What about others? Maria, Inas?
Yes, ma'am.
Okay, I can hear you as well. Can we just quickly test your cameras as well? I've got my colleague Vansh as well now. If everyone can maybe can I just check who all are present here? So at least then we can follow up with the remaining people who are not there in the round. Is our members, is the claimant present?
Yes, we're both present.
Yes, sir.
The respondent? So nobody from the respondent is here. And I believe we only have one judge. Anastasia, I believe you're the only one right now in the room.
Yeah, I believe so.
Okay. Can you hear me? Marjorie's here. No. Okay. I'm gonna. Anastasia, just for your information, the other two judges I think may have cancelled at the last minute. Mohammed and Tuba. That's the information I got from the DIFC. So as long as okay, I think Mr. Mohammed is here.
Hello, can you hear me?
Yes, Mr. Mohammed. Great. I can
Yes.
hear.
Yes. 1 minute, sir. All are joining. Sir. Just a minute.
Okay, sure. Do we have the respondent as well now? The University College, Law College, Bangalore University.
Yes, sir. This is University of
Sorry, I can't hear you. Can you speak up? The
Sir,
representative.
University Law. Yes, sir. The respondent. We are there for a respondent, sir.
Okay, have your team members joined?
Yes, sir. 1 minute, they're joining, sir. Just a minute.
Okay, sure.
Yes.
Do we have the respondents now? Everyone from University Law College, Bangalore?
Sir, we three are here. One person is not able to join, I guess. One
Okay.
person is
Can you send them this link that I'm putting in chat? If they're still unable to join,
okay.
can you give me their
Okay,
number
sir.
and I'll contact them?
Yes, sir. Yes, sir. 1 second, sir. I've sent them, sir. Three have joined here. Only one person is facing some issues. Just a minute, they'll join, sir.
Okay, sure.
Yes.
Hello, just inquiring if the other judges are present.
Sir, everyone is here now, sir, from University Law College. The
Okay, great.
respondents.
Okay, great. I think we can start the round then, Mr. Mohammed, Anastasia.
Yes, sir.
Over to you, and we can start.
Okay, can we start now?
Yes.
hope you can see me now. Are the senior claimant and the senior defendant are present?
Yes, sir. We are present, sir. Senior
Okay, senior on behalf of?
Respondent, sir.
Okay. Is the senior claimant present?
Yes, sir. Present.
Okay. Can you please first indicate and please present yourself first?
Okay, good afternoon. May it please the court, my name is Inas Al-Jahmi and I appear with my co-counsel Maria Nadim as counsels for claimant on the basis of two grounds issues where we'll be dealing with the first, which I'll be dealing with the first and my learned counsel the second. Now, if it pleases the court, shall I proceed with my submission?
No. Could you please first indicate how your team intends to divide the allotted time?
We each have our own sections of points, but I would say I would take around like 25 minutes, hers is 20.
And for that claimant, for the defense to counterclaim?
Sorry, your lord?
For the junior counsel claimant,
Yes,
the allotted time,
around 20 minutes.
20 minutes for each of you.
Yes. May I proceed with my submission?
Okay, Miss Anastasia, right? I can't hear you. You are on mute.
I would want to the claimant to properly indicate for whom they are acting in today's hearing.
Who's, sorry, your lord, I did not hear you.
Please, can you indicate for whom you are acting in the present hearing? What is the name of the claimant?
We are representing Artemis, the YouTuber, and I will be presenting as senior claimant, and my partner, my co-counsel will be Maria Nadim, which will be the junior claimant.
In the matter pertaining to?
Of the claim that was given from Solar Dream, we wanted to rightfully seek like $15 million in damages for Solar Dreams for violation and for their contractual obligations.
And who is the defendant against whom you will be representing?
Against Solar Dream.
Thank you. Please
Thank you.
proceed.
Yeah, I would like to start by bringing.
We want to hear the second party who is also need to present themselves. Who is they in the present proceedings today before you will start with your submissions?
Yes, Your Lordship. Now, may it please the court, my name is Inas Al-Jahmi and I appear with my co-counsel Maria Nadim as counsels for claimants on the basis of two ground issues where I'll be dealing with the first and my learned co-counsel will be with the second. Now, if it pleases the court, shall I proceed with my submission?
No, I think it's not clear. Now the defendant will present himself, okay? The other party will present himself. Thank you.
Good afternoon, Your Honors. So, my name is Mohammad Abdul Rahman, and I'm the senior defendant representing the Solar Dream Incorporation, and along with my co-counsel Kirtike, who is the junior defendant in this case. And Your Lordships, we'll be taking. I'll be taking 22 minutes, and my co-counsel will be taking 18 minutes of time, and will reserve 5 minutes for rebuttals. And
Thank
I'll
you.
be representing the. Thank you.
Can we please request the claimant, the senior counsel, Ms. Anas, to proceed with her submissions?
Yes, Your Lordship, thank you. I would like to bring this action against Solar Dream for its failure during a contracted space retreat mission. Solar Dream breached the spaceflight agreement between both the clients by failing to provide a safe and healthy environment as promised due to the COVID-19 outbreak. So, furthermore, if I may direct the court's attention to how Solar Dream committed gross negligence by launching the mission despite possessing knowledge of a potentially positive COVID-19 test result, causing a significant harm to our client and possibly the crew as well. So we also like to bring action to the court against Solar Dreams, alleging grossly inadequate safety protocols constituting both a tort and breach of contract, resulting in damages of totaling $15 million. So if I may proceed with the first issue, Your Lordship. So going through the first issue, where it comes to Solar Dream's liability, my lordships, as it is brought to this case, Solar Dream owed a legal duty of care to ensure passenger safety during the spaceflight retreat, as outlined in the space flight agreement. Exactly. So this duty extended to adequate medical screening, which they breached by failing to identify our client's undisclosed chronic headaches. So, relying on Solar Dream's safety protocols, our client was placed at risk and suffered harm due to their negligence. So, this constitutes to both a breach of contract, as Solar Dreams failed to provide a safe and satisfactory services as promised in the agreement, and a tort under the applicable law of DIFC Civil Code, which technically sets out the legal framework for civil liability, including tortious liability such as negligence. So, as
Can
their
I
actions,
request you? You were making the reference to the contractual obligations that were allegedly breached by the defendant, but you didn't do the reference and you didn't guide me to that. Will you do it further in your submission, so you want to do it now?
uh, I will, if I continue with my submission, I will get to that, Your Lord.
No, not. Please proceed.
Thank you. And as I said, their actions resulted in compensation damages for physical harm and loss of earnings. So Solar Dream's actions surrounding the launch demonstrates a reckless disregard for passenger safety, amounting to gross negligence, as mentioned. So their knowledge of the highly contagious Vulcan variant of the COVID-19 creates a clear duty of care towards all passengers on board. So launching the mission despite possessing a potentially positive COVID test exposes this disregard for passenger well-being. So we argue that a reasonable course of action would have been to delay the launch until a conclusive negative PCR test was obtained, and Solar Dream's decision to prioritize the launch window over passenger safety demonstrates a reckless prioritization of profit over well-being. So this action aligns with the legal definition of gross negligence, which is established by the DIFC Law of Obligations, where it basically defines gross negligence as a severe lack of care or recklessness that goes beyond ordinary negligence. So it also involves a conscious disregard for safety or rights of others. So this evidence suggests that Solar Dream acted with such disregard in this case. Now going into the sub-issue, which is the duty of care in space tourism as a whole. So while space tourism is relatively new to the industry, there are still existing legal principles that can be applied to this case, such as, for example, duty of care, regulatory compliance of passenger safety, contractual obligation, and much more. So, where in this case, the emerging body of space law also emphasizes the importance of safety and passenger well being. So, our client accords a set of non binding principles endorsed by many nations, including the UAE. So, the advocates for safety of astronauts and spaceflight participants as a whole. So, we argue that Solar Dreams, as a commercial spaceflight provider, has the duty to adhere to these emerging safety protocols. Now, during the COVID-19 pandemic, carriers had heightened the duty of care to implement appropriate health and safety measures to protect its passengers. So, cases like Barnett and American Airlines in 2022, it was established that airlines have a responsibility to take reasonable steps to mitigate the spread of contagious diseases on board. So, similarly, we argue that Solar Dream had a heightened duty to implement stricter screening protocols and contingency plans due to the pandemic of the new Vulcan variant. So we can find in the Federal Law number 14 of 2014 2014 on the control of communicable diseases in the UAE. It outlines the UAE's frame for preventing and controlling the spread of communicable diseases. So while it may not address spaceflight specifically, it emphasizes the importance of screening and isolation measures to protect public health. So we argue that Solar Dream's failure to implement the stricter protocols due to potentially positive COVID-19 tests, it's violated the spirit of this law as a whole. Now, another legislation I'd like to add, like the UAE Commercial Code, includes provision based on
Sorry,
the concept.
I just wondering, can you please let me know why we are applying UAE mainland law?
Uh, Pardon, Your Honor. Why what?
Can can you please explain me why we need to apply the UAE mainland law to the current dispute? Because it was not explained.
Uh, because it was based on the agreement, the jurisdiction was also based on the DIFC law in the UAE specifically.
Can you please guide me where we are invoking the argument why it is a DIFC law that shall be applicable to the current dispute?
Uh, my lord, because my lady lordship, because in the agreement itself with Solar Dream and our client, the jurisdiction was clearly mentioned that it will be based on the DIFC law, and it is a project based in the UAE itself, which what makes the UAE law applies.
Thank you.
Thank you, Your Lady. May I proceed?
Yes, please.
Thank you. So we argue that the another legislation, like as I mentioned, UAE Commercial Code includes provisions based on the concept of good faith in contract formation and performance. So we argue that her non-disclosure of our client of non-material headaches did not constitute bad faith, especially if they did not impact her ability to participate in the space retreat activities. So, proportionality and reasonableness of this case, we can say that even if some form of pre existing condition disclosure was expected, we argue that Solar Dream's response lacked proportionality. So, the headaches are common alignment, and not disclosing them shouldn't automatically disqualify her from participation, especially without evidence suggesting that they pose a health risk during the space flight. So, evident to that, International Civil Aviation Organization guidelines publishes guidelines for health measures in commercial aviation, so which can be argued as a relevant standard for space tourism, in the absence of specific spaceflight regulation. So, for example, like pre-flight health screening, which is implementing a pre-flight health screening procedures to assess the passengers for symptoms of illness or medical conditions, as they have done, and quarantine procedures where they develop procedures for isolating and managing passengers or crew members who will become ill during the flight, including protocols for medical evaluation, treatment, and isolation, or communicable disease management, so establishing protocols for managing communicable disease and outbreaks on board spaceflight, so including reporting requirements, contact tracing, and coordination with the public health authorities, and lastly, risk communication, which is providing passengers and crew with clear and timely information about health risks associated with space travel, as well as measures that they can take to protect themselves and others. So, my lordships, I would like to proceed by mentioning the limitations of liability and irrelevance of our client's non disclosure of her headache. And I would like to start by mentioning to the court that while Solar Dream may attempt to invoke limitations of liability clauses within the agreement, these clauses are not applicable in the situation of gross negligence. So, as established earlier, we argue that Solar Dream's actions constitute gross negligence, taking them outside the protection of these clauses. So, Solar Dream's personnel decided to take green light takeoff before receipt of the actual PCR test results because all lateral flow test was displayed negative as a result. But then the actual capsule and the actual receipts was launched, where shortly after the launch, the team received the transmission that one of the PCR tests has come back positive for COVID, which was from our client specifically. So, however, because of this, despite the efforts of the crew, within a few days, the passengers and the crew of the space flight had caught the COVID eventually, and the decision was taken to return Earth prematurely. So this caused our client's symptoms to worsen almost immediately upon the arrival and the space flight and or the space yoga mat, and caused her to be a little too well to even undertake any medication or yoga or even to film any of her videos. So, seen similarly in another case, like Alexander and NASA in 1992, where NASA breached in selection for procedure for the space shuttles, though it was discussed at the court whether they have sovereign immunity or not. It was seen in the case, however, as in this case, however, Solodream was reckless in their own agreement. So furthermore, SolarDream may attempt to leverage a client's undisclosed pre-existing headaches as a this justification of their actions. But however, our clients maintains that these headaches were not relevant to our ability to participate in the planned activities, and the declaration provided from SolarDream themselves clearly mentions that to the best of her knowledge and a belief, she was not aware of medical conditions or symptoms of any potential medical condition that may affect her fitness to participate in the spaceflight. So Solar Dream has not.
Alexander versus NASA. Can you please guide me through the main facts of the case and why shall it be applicable to our situation?
So the main facts of the case, Your Lordship, Your Lady Lordship, basically is when our well-known YouTuber, our client, which is Artemis, Artostia.
I'm talking about the mentioned and cited case that you just mentioned is Alexander versus NASA. So I'm talking about the facts of this case.
Yes, Your Lady Lordship. So the facts of the case where NASA they breached the selection procedures for the space shuttles for the astronauts, but with the decision of the court was that they were seeing if they have sovereign immunity or not, which basically meaning if they can be if because it's being a government company if they can be sued without consent or not. But relating to our case, it seemed like even though Solar Dream does not have sovereign immunity, so it was seen that they're reckless of their own agreement, not based on selection procedures only.
Please proceed.
Thank you, Lady Orchard. And I now would, if do you, does your lordships have any further questions? Then I would like to direct the second issue to my co-counsel to proceed. Thank you so much.
Your Honors, shall I start with my submissions?
I believe
Am I
yes.
audible, Your Honors? Yeah. Your Honors, so I'll be representing Solar Incorporation against the claims made by Miss Artemis. And Your Honors, the first issue is regarding the claim that is Solar liability to Miss Astrosia in tort and breach of contract. For the convenience of the court, I will be discussing this issue under two parts, that is liability in torts and the liability in contracts. Your Honors, with respect to the liability in torts, the council submits that no liability arises in torts as there was no gross negligence or willful misconduct on the part of Soladrim. My further arguments will also fortify that Soladrim has acted within the contractual and legal frameworks and responsibly managed the inherent risks of space travel and also took appropriate actions in response to unexpected challenges. Your Honors, with regards to liability in torts, I have two further submissions to make. Firstly, that the Soladrim is not liable for negligence and duty of care has been met. Your Honors, in regard to breach of duty, there is no breach in the present case. Your Honor, Miss Artemis' claim under torts is purely economical in nature. The council seeks attention of the bench to para 14 of the para 14 last three lines of the Moot proposition. Your Honor, this makes it clear that her claim is for her loss of earnings as a YouTuber due to her inability to film a series of space yoga sessions, which she had widely advertised and felt keen embarrassment about failing to pursue. Your Honor, the Article 20 of DIFC Law of Obligations states that where a claimant has suffered only pure economic loss as a result of the defendant's conduct, the defendant only owes a duty of care to the claimant if the requirement of Article 17 are met, the defendant assumes a responsibility to the claim. Now, the council seeks permission of the bench to Article 17 of the DIFC law of obligation. Your Honor, this liability clause under Article 17 states that a claimant must demonstrate that the defendant owed a duty of care, breached his duty, and caused damages as a result. It is submitted that while Solar Dream owed a duty to ensure safety, this did not specifically extend to ensuring Miss Astoracia could conduct her yoga sessions or manage her personal earnings from such activities such as YouTube. Your Honors, in the case of Capro Industries PLC versus Dickman, this is a leading English tort law case on the test for a duty of care. The House of Lords in this case set out a threefold test in order for a duty of care to arise in negligence. That is, firstly, harm must be reasonably foreseeable as a potential result of the defendant's conduct, and the parties must be in a relationship of proximity. And thirdly, it must be fair, just, and reasonable to impose liability. Your Honor, even though the parties, that is the Solar Dream and Artemis, are in a relationship of proximity, but still the other two conditions are not fulfilled in the present case. Therefore,
Can you please
no duty of
elaborate
care.
on the proximity issue?
Indeed, Your Lordships, on the proximity issue here, both of them have agreed for an agreement and they've signed the contract. Here, the proximity is in relation to that safety, to ensuring safety. But the other two conditions, that is, harm must be reasonably foreseeable and it must be fair, just, and reasonable to impose liability. These two conditions are not fulfilled. I mean, the Solar Dream is not liable since it is regarding the loss of earnings in her YouTube.
Yeah, but harm is foreseeable. So I would want to know, like, it seems that Miss Artemis is very well-known YouTuber, and according to the submission of the claimant, like, she is very well-known YouTuber. So I'm just wondering, was it not in foreseeable that she would want to make videos and to earn some money arising out of the videos based on her trip, because it seems that it's her preliminary focus. So can you please
The,
elaborate on the feasibility?
Thank you for your question, Your Honors. Your Honors, in the present case, the agreement doesn't even mention about her YouTube sessions. Your Honors, the the Solar Dream might not even be aware of the fact that she was a YouTuber. It was just it cannot be foreseeable in this instance, Your Honors.
Thank you.
The agreement doesn't mention also about that she can capture the sessions and all sessions, or she can capture the videos. So it cannot be a foreseeable event, Your Honors. And Your Honors, and the Article 10 of the DIFC Law of Obligations, which talks about the causation, it states that to establish liability under this law, a claimant must show that but for the defendant's conduct, he would not have suffered loss, and that the defendant's conduct was a substantial cause of his loss. This article, this says that a breach occurs when an act or omission directly leads to damage. But in the present case, the facts are very much clear that the loss suffered by Artemis is not at all a substantial cause of the defendant's conduct, and also no such breach occurred. In regards to the duty of care, the council submits that the Solar Dream has met the standard of care as required in the present case. The Article 21 of the DIFC Law of Obligations, it talks about the standard of care. It states that in order to establish a breach of duty of care, a claimant must show that the defendant failed to exercise reasonable care to avoid causing loss to the claimant, having regard to the probability and the likely seriousness of the loss. Your Honor, Solar Dream, as per the applicable laws, including the DIFC law of obligations, has acted within the reasonable care and skill expected of a spaceflight operator. This also includes adherence to all the safety protocols and regulations. Your Honor, the Council seeks attention of the bench to Clause 7 of the Spaceflight Agreement. Your Honor, this clause 7 of the spaceflight agreement fortifies the standard of care met by Solar Dream, and it has also followed the best practices and safety protocols outlined by international space travel guidelines and the human spaceflight activities regulations of the UAE.
Can
Your
you please guide
Honors,
me again to the article number?
Clause 7 of the Spaceflight Agreement,
The
Your
whole
Honors.
clause
Clause
7,
7.
not particularly exact one, right? Okay.
Clause 7 of the agreement, Your Honors. Your Honors, here it has additionally it has also implemented comprehensive safety protocols in compliance with the U.S. Federal Aviation Administration's recommended practices for human spaceflight occupant safety and the Space Industry Regulations 2021. Your Honor, this demonstrates a commitment to high safety standards, fulfilling their duty of care towards the passengers. The particular para 8 of the Moot proposition, it also makes it clear that the Solar Dream has also conducted pre-flight health screenings and also took and relied on expert medical advice. And the para 12 fourth line of the Moot proposition, this makes it clear that the advice of the nurse was also taken before the launch of the capsule. The advice of the nurse on duty was that a lateral flow test was sufficient statistically to rule out any kind of serious risk that passengers had COVID 19. But
Can you please
here,
elaborate? Like nurse doesn't seem to be a doctor, isn't it? So why would you rely on whatever nurse said? And like, is it actually that the nurse had the valid qualifications to advise on this issue?
in honor, the clarifications clearly mentions that the clarification mentions that there were some in the second paragraph, it clearly mentions that there were some initial evidence that some individuals infected with the Vulcan variant testing project. And also here the nurse is a uh, one second here, the para 6, which talks about the medical team, it clearly says that the nurse who conducted the examination on the day of the departure was hired on short notice from a local outsourcing company in the DIFC. She had been working at a local private hospital for the previous 10 years, where the Emirates Airlines pilots underwent a routine monthly medical test. So even the DIFC had accepted them, Your Honors.
Please proceed.
Yeah, sure, Your Honors. Here at this juncture, it is also important to refer para 11 of the Mood proposition. It says that on the morning of the flight, while carrying out the PCR test and the lateral flow test, a cursory medical examination was also done. But Artemis still hid her headaches. And since all the lateral tests came back negative, and since nobody had any kind of symptoms as the company was thinking, so it was assumed that they didn't had COVID. But if Artemis would have revealed her medical conditions, the Solar Dream would have taken further precautionary measures. Therefore, this decision to proceed with the flight is also supported by the medical professionals' advice, and this clearly proves that the standard of care for the space travel has been met. Your Honor, the Solar Dream has also acted swiftly and within the best practices of the industry to mitigate risks, prioritizing the health and the safety of all the onboard when it was faced with the unforeseen circumstances of the COVID-19 Vulcan variant. This is stated under para 12 and the last five lines of the Moot proposition, where upon discovering the positive COVID-19 PCR results, Solar Dream took immediate steps to mitigate further risk to the health of the passengers, complying with their duty to ensure passenger safety to the best of their ability under the circumstances. Your Honor, this proactive response aligns with the duty of care prescribed by Article 18 and 21 of the DIFC Law of Obligations, emphasizing the mitigation of harm when unforeseen events occur. It is to be noted that the space travel inherently carries risks, which were extensively communicated to and acknowledged by Miss Artemis through her acceptance of the spaceflight agreement. This understanding diminishes claims of unexpected negligence, Your Honor. Even the comprehensive pre-flight medical evaluations was also done by the company, and also during the evaluations, there was an obligation on the passengers to disclose any medical conditions, but Artemis failed to do so. Therefore, the company provided adequate medical oversight contingent on truthful disclosure by the passengers. Your Honor, now I'd like to move on to the second part of my arguments, that is, there is no breach of contract. Your Honor, Solar is a pioneer in commercial space travel and it stands firmly on the foundation of compliance with both the DIFC contract law and the DIFC law of obligations. Now, I will demonstrate that the claims brought about by Artemis Astrosia alleging gross inadequacy of safety protocols and breach of contract are without merits. Firstly, I'll be discussing about the contractual compliance and the informed consent. Your Honor, the clause 1.1 of the spaceflight agreement, this clearly states that Solar Inc. would provide a spaceflight experience, and Solar has fulfilled its primary contractual obligation by providing the flight to the space station as agreed. And any deviations to this were due to unforeseeable health emergencies that required an early return to protect passenger safety. The unforeseen need to return early was a result of health and safety considerations, which are standard in high risk operations like space travel. The early return was a consequence of unforeseen health risks and was not a failure to deliver the contracted service. Your Honor, the Solar
Can you
Dream has
please,
provided the agreed
you
service.
are talking about clause 1.1, right? Of the
Indeed, Your
agreement,
Honors.
space freight
Indeed, Your
agreement.
Honors.
Which one? Sorry.
Your Honors, the
I'm just very particularly interested in the citation of health issues that you have mentioned. That's why.
Your Honors, the clause 1.1 of the spaceflight agreement, it states that uh, one second, Your Honors. It says that it would provide a space flight experience, and what I am contending is that Solar has fulfilled its primary obligation, Your Honors.
Noted. Please proceed.
I'll be discussing further on this point in my further submissions, Your Honors.
Please
Your
proceed.
Honors, the unforeseen need to return early, it was a result of health and safety considerations which are standard in high-risk operations like space travel. And the early return was a consequence of unforeseen health risks and was not a failure to deliver the contracted services. Your Honor, the Solar Dream has provided the agreed services to the passengers. The para 12 and 13 of the Moot proposition makes it clear that the meditation and the yoga sessions went ahead. Artemis couldn't participate in this due to her own ability and she was too unwell to undertake any kind of meditation or yoga on her own. This retreat was provided for almost 4 days, and only on the fourth day, the decision was taken to return back to Earth prematurely so that the passengers are not at risk. Additionally, Your Honors, the agreement nowhere specifies as to for how many days this retreat will be provided. This is because it is contingent upon various factors, and at any point of time, there might be a need to return to Earth prematurely, and the passengers have also agreed for these terms. Your Honors, the clause 1.1 of the agreement clearly states that the spaceflight operator agrees to provide the passenger with a spaceflight experience on or around 15 February 2024, subject to a launch window presently expected to open on 14 February and to close on 23rd February. Your Honors, the launch window is contingent upon various factors, including but not limited to meteorological conditions, technical readiness of the spacecraft, and regulatory approvals. Therefore, Your Honor, the agreement includes clauses that provide for adjustments to the itinerary in response to unforeseen circumstances or emergencies, thus protecting Solar Dream against claims of breach due to non-delivery of the full experience. Under the DIFC contract law, Your Honors, particularly the principles relating to the performance of contracts and informed consent, the Solar Dream has meticulously adhered to all contractual obligations. The spaceflight agreement entered into by both the parties clearly stipulates the responsibilities and the inherent risks associated with space travel. And Miss Astrosia was fully informed of these risks and voluntarily agreed to them as evidenced by her signature on the agreement. This consent absolves Solar Dream of liability for events that are inherent risk of space travel. To strengthen my submissions, Your Honors, the Council would like to submit that the outbreak of the COVID-19 on the spacecraft also constitutes a force majeure event. The Article 82 of the DIFC contract law, this talks about force majeure event. It states that except with respect to a mere obligation to pay, non-performance by a party is excused if that party proves that the non-performance was due to an impediment beyond its control and that it could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract or to have avoided or overcome it or its consequences. Your Honor, this Article 82, this permits a party to invoke force majeure in cases where external uncontrollable events prevent contractual performance. Even in the present case, the emergence of a new COVID-19 variant absolves Solar Dream of liability for full performance under the agreed terms. Further, the contractual terms are also clear about the potential for unforeseen adjustments and includes limitations on liability that would apply to situations like this, therefore reducing the scope for claims of breach. Your
Can
Honors,
I,
I'll cite a
if there
case.
is, if there is any force majeure clause in the agreement,
The first, indeed, yeah, Your Honors.
why I
Could you
should
repeat the
invoke
question?
DIFC law or agreement?
Your Honors, could you repeat your question, Your Honors?
I'm just wondering, you're citing DIFC law on force majeure, isn't it? So I'm just wondering, in the contract, there is no force majeure clause. That's why we're invoking DIFC law, or there is a clause of force majeure in the agreement.
Your Honors, Your Honors, but in the DIFC law of contracts, it is mentioned in Article 82 of the contract, Your Honors. So here the DIFC laws has to be applied because they have submitted it to the submitted to the DIFC courts, Your Honors.
Okay, please proceed.
Indeed. Your Honors, in case of Matsokis versus Policeman and Company, it was stated in this case that the effect of a force majeure clause is that it enables a non-performing party to escape liability for failing to perform as a result of the force majeure event. Your Honors, now I'll move on to the last part of my submissions, which is regarding the limitations and exclusions of liability and assumption of risk by Miss Astrosia. Your Honors, the clause 4.4 and the 4.5 of the spaceflight agreement explicitly limits the Solar Dream's liability for unforeseen or uncontrollable events. Your Honor, the clause 4.4, it states that the passenger understands and accepts the possibility of unforeseen events or emergencies during the space flight, including but not limited to equipment malfunctions, changes in mission plans, or other factors that may necessitate adjustments to the itinerary or procedures. And further, Your Honors, the clause 4.5 states that subject to applicable law, the spaceflight operator shall not be liable for any loss, damages, injury, or expenses of any kind arising out of or in connection with the spaceflight except for liability arising from the gross negligence or willful misconduct. Your Honors, here the Solar Dream is not liable because there is Miss Astrosia's own negligence in disclosing her health status. Your Honor, both the clauses caps potential damages and explicitly details the risk involved in the space travel which were acknowledged by Miss Astrosia. It further explicitly excludes certain types of damages, thereby protecting the operator from unforeseeable and uncontrollable risk. Further, Your Honors, the spaceflight agreement also contains clauses that limit the liability of Solar Dream for incidents that are beyond its direct control, including health issues arising from undisclosed conditions. The Solar Dream liability does not arise as it is clearly mentioned according to the clause 5.5, which states that the passenger acknowledges that they bear the responsibility for promptly reporting any changes in their medical condition to the spaceflight operator, and that failure to do so may impact their eligibility to participate in the spaceflight. Your Honor, it is also submitted that Solar Dream has provided the spaceflight experience as agreed upon by the parties, but due to emergency conditions, it had to prematurely return to Earth, due to which the full experience could not be provided. And this per se cannot make the Solar Dream liable for any kind of breach. And Your Honor, this is also permissible under the Article 84 of the DIFC contracts law. The Article 84A, which talks about the performance of non-monetary obligation, provides that where a party owes an obligation other than one to pay money does not perform, the other party may require performance unless it is impossible in law or in fact. Therefore, Your Honors, in the present case, the facts are categorically clear that the full performance was impossible in law and also in fact. Further, the space flight agreement under section 14 clearly includes clauses where Miss Astrosia acknowledged the inherent risks associated with the space travel, which would cover unforeseen health risks and operational adjustments due to those risks. Your Honor's reliance could also be placed on Article 55 of the DIFC Law of Obligations, which deals with the assumption of risk. Your Honors, it states that a defendant is not liable to a claimant under Chapter 2, 3 of this part if the claimant has knowingly subjected himself to the risk on which the claim is based and the claimant wishes to subject himself to that risk or agrees to subject himself to that risk. Even in the present case, Your Honors, Miss Astrosia has signed the agreement and agreed to the terms, and she herself subjected herself to these risks also by not disclosing her health conditions. Therefore, the liability of Solar Dream does not arise. Your Honors, the court must also recognize that these limitations were agreed upon by both the parties and are enforceable under the laws of the DIFC, providing a clear boundary within which liability should be assessed. To sum up with my arguments, Your Honors, the Council submits that Solar Dream has not only adhered to the contractual and legal obligations set forth by the DIFC laws, but has also taken every conceivable step to ensure the safety and well being of its passengers, including Miss Astrosia. The claims of gross negligence and breach of contract are contradicted by the evidence of rigorous compliance and responsible conduct by the Solar Team. We request that the court dismiss these claims and recognize the enforceability of the contractual limitations and exclusions as agreed upon by the parties. With this, I sum up my arguments, Your Honors.
Any conclusion? That
Yes, Your
was
Honors, I've
conclusion.
concluded.
Thank you.
Yes.
I have a question, please.
Any, Your
Um,
Honors.
Yes, please. After the first examination, all the travelers checked in the pre-departure accommodation in the dream house for 2 weeks. So that which means that they didn't have any examinations during this period. And despite there's a spread disease during these 2 weeks, you have only relied on the nurse's advice, not only a written declaration that you can go with the flight without having the results of the PCR tests. So
Your Honors.
yes, please.
Yes,
So
Your Honor. Yes,
let's
sir.
you have relied in the duty of care point that there wasn't disclosure from the claimant about her symptoms. So what if we assumed that any of the other travelers have caught this disease, this spread disease during this period? How would you know, or how could you rely on a nurse's advice without having the results of the test, of the PCR test? Do you think, or do you believe that you have complied, or your client has complied with the duty of care to assure the safety of all the travelers by not having the results of the test, or by relying on the nurse's advice, which is not even a written declaration from the nurse, or from a health like hospital or a doctor?
Your
Also, I
Honors,
heard
the para.
yeah, please. Also, I heard your words about that. She is an experienced nurse, but is that maybe considered as a replacement for the test, or for the results of the test?
Your Honors, I'll be the paragraph. I'll be discussing in terms of the Moot proposition, Your Honors. The paragraph 18, it clearly states that 2 days after she has purchased her ticket, she was contacted by the employees of the Solar Dream and was told that she had to carry out a medical evaluation before she could board the flight. And Your Honors, she was also given a medical history log and she was asked to list all the ailments that she suffers or previously suffered. And following this, Artemis was also asked to meet with a specialist doctor from Solar Dreams team who conducted a physical examination and carried out a few tests to check her fitness level. And even during this point, Your Honors, the paragraph 8, last second line, it states that Artemis made no mention of her chronic headaches because she was afraid that Solar Dream would not allow her to participate in the retreat. But Your Honors, our duty has been done. We have provided all the medical facilities, Your Honors, and also the claim regarding the PCR test. Your Honors, here in this case, uh, in relation to the lateral test and the PCR test. The lateral test were almost proving that if anybody had COVID, and the lateral test were coming positive for them, Your Honors. The clarifications page also mentions about the same. So the solar dream, it assumed that nobody had COVID, since nobody had any kind of symptoms. Nobody were aware of any kind of symptoms, so they could go ahead. With this assumption, the solar dream had taken off the flight, Your Honors. So this was, if Artemis would have revealed her conditions, then the solar team would have taken uh, further further regulations, Your Honors.
Thank you. But now you are relying in the duty of care on assumption.
Your Honors.
You are relying in the duty of care on assumption that because of they have disclosed that they don't have any symptoms or something like this. So now you can go
No,
with
Your Honors, we are relying on the medical evidence provided by them, and also the lateral test. The lateral tests are like, if we discuss it, it is almost 80 to 90% positive. Like, we can rely upon it, Your Honors. 80 to 90%. The probability is about 80 to 90%. So if she had COVID, it would have been revealed at that point of time. So in that, with that assumption, we went ahead, Your Honors.
thank you.
Thank you.
May we please request the senior claimant for rebuttal relating to the claim?
Yes, Your Lordship. Uh, may I start?
Yes, please.
So, our senior the defendant has mentioned that we have not proved anywhere that that Sology did not put any gross negligence, when clearly in the piece, as mentioned by our lordships, when it comes to relying on a nurse's advice, when clearly in the International Civil Aviation Organization, when it comes to communicable disease management, they clearly mentioned that establishing protocols for managing communicable diseases and outbreaks on board spacecraft, including reporting requirements, contract tracing, and coordination with public health authorities, when clearly Solar Dreams relied on only a nurse's advice and from a lateral flow test, which is not a confirmed PCR test, which also comes to another guideline where it comes to risk communication, where providing the passengers and crew with clear and timely information about health risks associated with space travel, as well as measures that they can take to protect themselves and others. But in their declaration of the agreement itself, quote, it said that the best of her knowledge and belief, if she was not aware of any medical conditions or symptoms that could affect her flight, where our client did believe, even based on the declaration, that her headache would not affect her participation in the flight. And also, you mentioned that there was no mention in the agreement or in the announcement that there was a timely manner for this event, when clearly they mentioned that this event was going to be for a week long, but they only reduced it to 4 days based on Solar Dream's negligence on getting on duty of care and for the safety of the passengers, which led to the event to be only for 4 days from the COVID outbreak.
Do you want to address the issue of force majeure or duty of care?
I'd say negligent, the gross negligence.
Please proceed.
I'm done with my rebuttal. Thank you.
Thank you.
Your Honor, shall I start with mine?
Yes, please.
Your Honors, the senior claimant mentioned that there is negligence. Your Honors, the Solar Dream is not contending that they relied only on the nurse advice, Your Honors, but we are relying on the lateral test, Your Honors. The lateral test, there were initial evidence, as I already mentioned that there in the clarifications page, that there were some initial evidence that some individuals infected with the Vulcan variant were testing positive. Your Honors, the the doctors and the nurses, they believe that if this has came negative, then and if they didn't had any kind of symptom, that means that they would not have COVID. So with that intention, we proceeded with the space flight, Your Honors. And the second point, which the senior claimant mentioned, that the best of her knowledge and belief, Your Honors, the Moot proposition, it clearly mentions that she was afraid. She was afraid that due to her chronic headaches, Solar Team would not allow her to participate in the retreat. You know, for the best of her knowledge, this also include that whatever medical history or medical lot she had to uh, disclose it to the Solar Team, Your Honors. And also, uh, the paragraph 5 of the Moot proposition, it also says that she was suffering from headaches from past 5 years, chronic headaches. And despite seeing a number of doctors and trying various alternative remedies, she has not been able to stop the headaches from recovering. So, Your Honors, this makes it clear that she has not given the information to the best of her knowledge and belief, Your Honors. With this, I conclude with my submissions, Your Honors.
Thank you. Can we please request the junior defendant to start with counterclaim?
Your Honors, junior defendant. Good afternoon, Your Honors. I'm Kirti K, junior defendant in the case or in the instant case representing Solar Dream. Your Honor, I'll be dealing with the second issue, which is regarding the counterclaim, that is Ms. Astrocia's liability to Solar Dream for a breach of contract. Your Honors, for the convenience of the court, I'll be making my arguments in two parts. Part A, I'll be dealing with violation of spaceflight agreement by non-disclosure of medical condition. And in part 2, I'll be discussing about Ms. Atria's liability to compensate Solar Dream for the breach of contract. Your Honor, it is submitted that Ms. Atria is liable to Solar Dream for the breach of contract as she failed to disclose her medical condition, causing a breach of the spaceflight agreement. Further, Your Honor, uh, coming to part A, that is, Atrimus violated the spaceflight agreement by non disclosure of medical condition. Your Honor, the para 7 of Moot proposition clearly states that Ms. Atrimus Atrocia had read and signed the space flight agreement, which was mandatory for all the passengers, and this makes it clear that she had an obligation to act in accordance with the said agreement. Your Honor, both the DIFC law of contracts and the Unidroit principles from the articles 5.1.1 to 5.1.7, which talks about the performance of the contractual obligation, mandates that contractual obligations must be performed as it has been agreed, and the parties are bound to fulfill their obligations according to the terms of the contract.
Sorry, so
Firstly,
you allege that Ms. Artemis was supposed to disclose the information under the contract, but can you please guide me where exactly it's written?
sorry, Your Honor, can you please pardon?
Can you please guide me to the contractual obligation, if it exists, that Ms. Artemis was supposed to disclose the information under the contract?
Indeed, Your Honor, in the Moot proposition,
In the
para
contract.
7, it is read as when the purchasing ticket was provided to Artemis, Artemis read and signed a copy of the space flight agreement, which was mandatory for all the passengers. Further, Your Lordships, in the next paragraph, in paragraph 8,
I'm interested in the contract where it is contractual obligation of the other party to disclose the information,
Your Honor.
where it is written in the contract that Ms. Artemis, in the contract, that Ms. Artemis was supposed to disclose the information.
Indeed, Your Honor. That's what in the para 8, in the declaration that Solar Dream and was told that she had to carry out a medical examination. Here, the Artemis was contacted by the employees of Solar Dream and was told that she had to carry out a medical evaluation before she could board a flight. In
So
subsequent
you're alleging that there is no contractual obligation for the Ms. Artemis to disclose the information under the contract. This is what I understand. It's only from the Moot facts that she was supposed to disclose the information. Am I right?
Your Honor, by the contract formed between the two parties and the subsequent medical evaluation and declaration provided to Artemis, specifically mentions that she was obliged to disclose all her medical conditions
So
that she
where
was
in the contract it is written? Can you please guide me in the contract to this provision?
in the space flight agreement contract.
Clause number.
Yes. Your Lordship, clause 5.4 of the spaceflight agreement. In the event of the change in passenger's medical condition, in the reasonable opinion of the spaceflight operator, that may affect the ability to safely participate in the spaceflight, the spaceflight operator reserves the right to deny boarding to that particular passenger. So this clearly states that the passenger who was undertaking the space flight travel was obligated to disclose their medical conditions which materially affected the space mission.
Please proceed further with your
My
submissions.
pleasure. Firstly, Your Honor, Artemis, by signing the agreement, was obligated to discharge specific responsibilities. Secondly, in furtherance of the same, she was required to undergo a medical evaluation and disclose all her known medical conditions. But in the instant case, Miss Artemis breached the spaceflight agreement by failing to declare her medical condition, which constituted the violation of agreement. Further, Your Honor, I'll be substantiating this part in two folds. Firstly, violation of clause 5.2 of spaceflight agreement. Your Honor, it reads as the passenger declares and represents that to the best of their knowledge and belief that they are not aware of any medical conditions or symptoms of a potential medical condition that may affect their fitness to participate in the space flight. Further, the passenger acknowledged the importance of providing accurate and complete information during the medical evaluation. Your Honor, here there is a clear breach of this clause by Ms. Atrimus. The counsel seeks attention of the bench to para 8 of the Moot proposition, wherein, in addition to carrying out a medical evaluation, Ms. Artemis was also provided with a form which provided that, to the best of her knowledge and belief, she was not aware of the medical conditions or symptoms of a potential medical condition that may affect her fitness to participate in the space flight. Further, Your Honor, she was also given a medical history log and asked to list out all the ailments that she had suffered and was suffering presently. But however, in this entire course of due diligence, Miss Artemis did not mention anything about her chronic headaches. And the reason for this is also clearly mentioned in para 8, which states that she had not disclosed the same with an apprehension that Solar Dream would not allow her to participate in the retreat.
Sorry, you are making the reference to paragraph 8 of the agreement, or what is this paragraph 8?
Proposition, Your Lordship. Moot proposition. May I proceed, Your Honor?
Yes, please.
Further, Your Honor, in the case of Mutual and Federal Insurance Corporation Limited versus Outshone Municipality, it was held that duty of disclosure extends to constructive knowledge. In other words, knowledge which the contracting party would have been able to ascertain, which would be material to the terms for consideration at the time of conclusion of the contract. Your Honor, in the present case, Artemis has clearly breached the contract. She was aware of her medical conditions, about her chronic headaches. The para 5 clearly mentioned that she had been suffering from chronic headaches for over a past 5 years, and despite seeing a number of doctors and trying various alternative remedies, she had not been able to stop the headaches from recurring. Hence, Miss Artemis Atrocia violated this rule by during the medical evaluation and concealing the information about all her ailments that she suffered and was previously suffered and was suffering. Hence, Your Honor, if she had disclosed these chronic condition, additional precaution would have been taken by the defendant, Solar Dream, so that or by deeming her unfit for the space mission or by taking some precautionary measures. Moreover, Your Lordship, this also goes against the Article 1.7 of Unidroit Principles, which talks about good faith and fair dealing. Your Honor, as per this principle, parties must act in accordance with good faith and fair dealing in the international trade. This encompasses honesty, openness, and consideration for the interests of the other party. But in the instant case, Your Honor, was atrocious failure to disclose her chronic headaches, which is a significant and relevant medical condition to undertake the space mission, is clearly a violation of the principle of good faith. Her non disclosure withheld critical health information that would impact her safety and also the safety of other passengers and crew members, resulting in the overall risk assessment. Hence, Your Honor, Miss Atrocia's failure to disclose her chronic headaches, which she had been experiencing from past 5 years, and for which she had sought multiple medical opinions, and her non-disclosure about the same constitutes a direct violation of the terms agreed upon in the contract, thus
Can I
making.
just request you? You are referring to UNIDROIT principles. What is the like how UNIDROIT principles are generally applied?
Your Honor, Unidroit principles are generally accepted in the countries which follow common law. These are internationally accepted principles in respect to contract and tort.
I
Um,
will rephrase my question. In order to apply the UNIDROIT principles exactly for the situation, do they need to be implemented into the contract?
Your Honor, though these Unidroit principles having a international being the international principles might not have binding effect, but still they have persuasive effect in this matter, Your Honor.
So, just in general, in order to implement UNIDROIT principles, they should have been incorporated in the contract. Do I understand correctly that they are implemented into the contract?
Your Honor, sorry.
Is there any reference in the contract that they are agreed between the parties?
Your Honor, the in the Moot proposition, it clearly mentioned that the parties, while arguing the issues, can refer to some the international principles, the authorities from the common law nations, and including the DIFC judgments. So, based on that, this international principles, unitary principles, can have a persuasive effect on this matter.
Thank you. Please proceed.
Much obliged, Your Honor. Coming to the second fold of the submission, Your Honor, violation of clause 5.3 of the space flight agreement. Your Honor, it reads as the passenger who undertakes to promptly inform the space flight operator if there is any change in their medical condition or if they become aware of any medical symptoms that may affect their fitness for space travel. This include any changes that occur between the time of initial medical examination and scheduled launch date. Your Honor, this clause makes an obligation on the passengers that they should promptly inform if there is any change in their medical condition. Miss Artemis, during the second week in the quarantine, began to suffer from severe headaches. The para 10 of the Moot proposition makes it clear that even on the launch date, her headache continued and she began to get tired. But however, she covered it up and proceeded with the space mission. Even when the passengers were given a cursory medical examination and also given a lateral flow test and a PCR test to check the virus, Artemis made no mention about her chronic headaches to the nurse. Further, Your Honor, if she had mentioned about her chronic headaches or even the changes in her medical conditions during the second week of quarantine, precautions and reasonable efforts might have been taken according to the clause 5.4 of the agreement. But Artemis did not disclose the same to anyone, and hence she led to the failure, which this failure constituted the breach of contract, and she is liable to Solar Dream. Your Honor, moving on to the second part of my argument, that is, Miss Artemis is liable to compensate Solar Dream for breach of contract. Your Honor, the aggrieved party is entitled to full compensation for the harm suffered as long as it is a consequence of a breach. Article 110 of the DIFC contract law and Article 7.4.2 of Unidroit principle explicitly states that the aggrieved party is entitled to full compensation for harm sustained as a result of the non performance. Such harm includes any loss which is suffered and any gain of which it was deprived, taking into account any gain to the aggrieved party resulting from the avoidance of cost or harm. The Article 7.4.2, paragraph 2 of the Unidroit principle expressly provides for compensation only also of the non-pecuniary harm. This might include, Your Honor, any pain and suffering, loss of certain amenities of life, aesthetic prejudice, as well as human harm resulting from the attacks of honor and reputation. In the case of Withers versus General Theatre Corporation Limited, in this case, Your Honor, the plaintiff, a variety artist, was engaged by the defendant to appear and perform a certain sketch at the London Palladium. In the breach of contract, the defendant refused to allow him to perform at the London Palladium. The question before the court was, in his action for damages for breach of contract, the plaintiff was entitled to compensation for damage of his existing reputation, for which the court recognized that the damages for breach of contract may properly include such a sum as the jury may award to compensate the plaintiff for loss of reputation which would have been acquired or damages to reputation already acquired. Your Honor, in the instant case, the essentials of materiality of breach is satisfied. A breach of contract is material if it results in such a detriment to the aggrieved party as substantially to deprive them of what they are entitled to expect under the contract. Your Honor, in the instant case, the non disclosure by Artemis is material because it directly impacted the operational safety and financial integrity of the spaceflight. The contracting with Vulcan variant of COVID-19 and subsequent cancellation were consequential to her failure to disclose about her chronic headaches, for which Solar Dream could not have foreseen, thereby fulfilling the materiality required for a breach. Therefore, Your Honor, in the instant case, Solar Dream can claim damages for the reputational harm and financial losses due to the cancellation of future bookings, which are a direct consequences of Ms. Atrocia's breach of non-disclosure. With this, the counsel would seek to sum up their arguments, Your Honor.
Please.
Your Honor, with respect to counterclaim, it is submitted that the contracting with COVID-19 and the subsequent cancellation of mission was consequential to the failure of Artemis' non-disclosure of the ailments. Therefore, in the instant case, Solar Dream can claim damages for the reputational harm and financial losses, and the Artemis cannot transfer the blame upon the Solar Dream for the negligent act, as she herself is in the position of default. Much
This concludes your submissions.
Yes, Your Honor.
Thank you.
Thank you.
Can we please request the junior claimant for defense to counterclaim?
Yes, Your Lordship. So, my name is Marian Nadeem, and I'm the junior counsel, and I'll be dealing with the second issue, which is the breach of contract. So, Ms. Atrothia's action could be contextualized within the framework of a genuine desire to participate in the space retreat and the perceived risk of being disqualified. So, firstly, Ms. Atrothia's decision not to disclose about her chronic headaches could be associated with her deeply entrenched aspiration to partake in this unique experience as an individual deeply committed to the yoga practice and with a strong interest in space exploration. The opportunity to combine her passions in an extraordinary setting like the space yoga mat was undoubtedly a life once in a lifetime experience for her. So, given the peculiarity and high demand for participation in such space flights, Miss Estrosia uh, felt immense pressure on her to secure her position in this. And basically it was that it could perceive, because if she could tell about her medical condition, it would jeopardize her chance to be a part of this futuristic experience. Moreover, Miss Astrotia's failure to disclose about her chronic headaches could be framed as a result of her genuine belief that the condition did not pose a striking risk to the safety of the flight nor the fellow passengers. The As someone who has managed her headaches over the years with her daily life activity, should not perceive that her condition was not manageable. Additionally, given the lack of explicit guidance on what medical conditions could disqualify a passenger from participating in the retreat, Mr. Astrotia was uncertain when her headaches constituted a disqualifying factor. Furthermore, Ms. Astrotia's decision not to disclose her chronic headaches could be viewed through the lens of a desire to avoid potential disqualification from the retreat rather than a deliberate attempt to deceive Solar Dream. Ms. Astrotia was a successful YouTuber, and through her earnings, she had invested a significant amount of resources and anticipation into this space yoga retreat so that she could film, and it's about her reputation. The idea of being unable to fulfill her commitment and aspiration due to her medical condition would have devastated her both personally and professionally. So, in addition to prove above mentioned points, I would like to add more. That is, first and foremost, there was absence of clear guidance from Solar Dream. The spaceflight agreement did not provide with the clear guidance as to the specific medical conditions that could disqualify a passenger from participating in the acting in this good faith. Mr. Astrothia acted in good faith throughout the process. Her intention was participate in the retreat and contribute positively to the experience. Third one is unpredictability of headaches. Basically, Mr. Athosia's condition has been episodic and manageable with medical condition. So it was unpredictable that her headaches would constitute a significant health risk during the flight. Financial investment. Mr. Astrothia's substantial financial investment in pursuing the risk, in basically purchasing the ticket and planning the video series, underscores her commitment to the retreat. The potential loss of income in the event of disqualification was considerable. The lack of adverse effect. The Miss Astrothia's chronic headaches did not result in adverse effect during the flight preparation. It was only after onset of the Vulcan variant, after which the conditions become relevant. The limited impact on safety. Miss Astrothia's chronic headaches posed minimal risk to the safety of others on flight, hence, it was not contagious. The UA Commercial Code includes provisions for the implied warranty of merchantability, which means a product or service which is unfit for the ordinary purpose of which it is sold for. The Artemis can argue that the space retreat experience inherently implies a safe and healthy environment. Solar Dream's failure to prevent the COVID-19 outbreak constitute a breach on this implied warranty. According to the case law on fitness for purpose, like Standard Chartered Bank versus Due 2002, it established the principle that a seller is liable if a product is not fit for the purpose for which it was bought.
Can you
Similarly,
guide me through the facts of the case for which this conclusion was made? So we will consider the why this case will be applicable to the current situation. The
yeah, Ms.
similarities of the facts between both cases.
Yes, so a lordship, the in this case, basically, Chartered Bank was a seller of goods, but Due bought it, and it was unfit for, and it was basically causing harm to her physically. So therefore, it was returnable. So basically, in this, similarly, Artemis can argue that the space retreat was not fit for its intended purpose due to the presence of COVID-19. In addition to emotional distress and potential health risk, Artemis can claim compensation for monetary value of the compromised retail experience. This could include the cost of the trip, any missed work opportunities, and the cost of medical expenses incurred due to the exposure. Also, if we look into the paragraph number 9, sorry, 11, and line number 9, all of the lateral flow tests,
Of
including
what? Of which document?
of the Moot proposition.
Mm-hmm.
All of the lateral flow tests, including Artemis, came negative. Artemis waited to get back the results of a PCR test, but she was informed that due to the delays in the lab, the test results would take more time than anticipated to come back. Therefore, they assumed that it was fine for them to go without the test results. So basically, in clause number 4.5, lateral test is basically an antibody test. So Solar Dream assumed
4.5 of which document?
Moot preposition 4.5.
Okay.
Basically, lateral test is an antibody test. So Solar Dream assumed that all the tests would come negative, and it clearly mentions in 4.5 that subject to applicable law, the space flight operator shall not be liable for any loss, damage, injury, or expense except for liability arising from gross negligence or misful conduct. In all circumstances, the space flight operator total liability for any and all claims should be limited to maximum of USD 1 million. Thank you.
Thank you. Can I please ask the junior defendant for rebuttal?
Indeed, Your Honor. Your Honor, firstly, going with the argument of the junior claimant, mentioned that the beliefs and aspirations of the individual, uh, beliefs and aspirations of Astrosia went her to proceed with the space mission. But however, Your Honor, the beliefs and aspirations of an individual cannot in any way justify their conduct, their actions for breach of contract. Further, Your Honor, paragraph paragraph 7 of the Moot proposition clearly mentions that if the individual is suffering from any potential health conditions, they must reveal it in the agreements and also in the declaration. This is based on the logic that the persons who are undergoing any potential health conditions may be prone to the diseases, may be prone to the viruses easily. That was the logic behind this provision, and hence Atricia was liable to disclose, was obligated to disclose all her medical conditions. Further, Your Honor, in section 17 of Article A 17 of Law of Obligations, DIFC Law of Obligations, 17 Clause 2 mentions that the defendant's liability provided in Article 17 Clause 1 shall be reduced by the extent to which the claimant's negligent acts or omissions contributed to the loss. In this, by going by this provision, Your Honor, here the negligent omissions and the concealment of medical conditions on the part of Atricia has reduced the liability, or in other way has imposed liability on Atricia uh, uh, to prove the breach of contract rather than on Soladri. Further, Your Honor, section 86 of Section 86 of the DIFC contract law permits the termination where the failure of other party to perform an obligation under the contract amounts to a fundamental non-performance, the certain ascertainment of which will have a regard to a number of factors, including whether the non-performance substantially deprives the aggrieved party of what it was entitled to expect under the contract, and whether it has a reason to believe it cannot rely on the other party's future performance. In the instant case, to Your Honor, the default on part of Atricia has significantly affected the future performance of the contract by Soladri. Uh, I would like to bring to the attention of the bench that there were four instances or opportunities that were provided to Atricia to reveal her medical conditions. Firstly, in paragraph 7, when the agreement was formed between the two parties, and subsequently in paragraph 8, where a declaration form was provided and a medical evaluation was conducted by an experienced doctor. Thirdly,
Experienced doctor
the
or nurse?
Your Honor,
Experienced doctor or the nurse?
experienced doctor, Your Honor.
Yeah, please write me, yes.
Paragraph 8 mentions that she was conducted a thorough physical examination by a specialist doctor.
Okay.
Thirdly, Your Honor, uh, the clause in the agreement mentions that any period between the initial agreement date to the scheduled launch date, anywhere between this period, if the passenger has any issues with their health, they are obligated to disclose it to the company. And subsequently, Your Honor, in paragraph 10 of the Moot proposition, it's mentioned that just before the launch of this space flight, Atricia suffered from severe headaches. Even then, she preferred not to disclose it to the company. And subsequently, even during the examination for the COVID-19 virus, despite of knowing the severities of the situation, she chose to not disclose it, which led to willful concealment of facts on the part of Atrocia.
I
Further, your
just please, Mr. Mohammed, let me know if you would consider the same. I understand that the council is just repeating the claim. So I just want the council to focus on actual point that another council was trying to bring, is that Miss Atricia was trying to, like, okay, believes it's probably the disputable point, but she had an honest belief in whatever she was trying to do was right, and there was nothing to deceive in according to her. So can you please elaborate on this point, because the claim we already heard.
Your Honor, in this case, Atrocia firmly believed, or in a way, it was her misconception that performing yoga in a low gravitational field will realign her neurons and hence will help her to overcome the headache. There are no scientific studies or claims to support her beliefs. In the absence of that, her beliefs or aspirations to participate in the space flight mission cannot justify or cannot be proportionate to her breach of contract which was formed between which was entered with Solar Dream.
This ends your submissions.
I just have one more rebuttal to make, Your Honor, if you permit.
Pertaining to which point?
Your Honor, which regarding to para 14 of the Moot proposition, Atrocia
Wait.
imposes liability on Solar Dream based on two claims. Firstly, what she says is a failure by Solar Dream to provide her services that she paid for. And secondly, her loss of earnings as a YouTuber due to her inability to film a series. Your Honor, with respect to the first claim that she making, in the claim, it did not provide that, did not fulfill the contract was not fulfilled, or what the services was not provided only because of the negligent omissions and concealment of the medical conditions on the part of Atricia. In this case, there was no negligence or misconduct on the part of Solar Dream which led to the aborting of the mission, but rather it was the negligence on part of Atricia in concealing her medical conditions which led to non-fulfillment of the services or the breach of contract. Secondly, Your Honor, with respect to second claim that her loss of earnings as a YouTuber due to her inability to film the series. Your Honor, it is clearly mentioned in the Moot proposition that uh, paragraph 13 that Atricia was unable to undertake any yoga activities or
Just
perform
that.
meditation.
Sorry, I believe that you are just yeah. Can you please focus on this is the rebuttal, right? So we are highlighting the main points. So I just
Uh,
want you to focus on whatever was brought in the defense by the opponent. So defendant brought the point of breach of the contract, and I just want you to focus on how the contract was not breached, rather than making your like defense, because it's actually another procedural stage currently.
Indeed, Your Honor, the council here seeks to provide justifications for the compensation or the claims made by the claimant, the financial claims made by the claimant, and how those two claims do not have a merit in the instant case. I just want to
To breach of
mention
the
one
contract.
point in that regard, and I'll be completing with my rebuttals, Your Honor.
I just
Uh,
want to hear about the breach of the contract. Okay, so this is what I want to focus on.
Indeed, Your Honor. Lastly, Honor, this loss of earning here, Atricia was personally contracted with COVID-19, and according to paragraph 13, she was too unwell to undertake any meditation
Paragraph
or
13 of
yoga
what?
or to perform the videos, record the videos of the space retreat. So hence in this case it was not the default on the solar dream, but rather the default on her part for for not recording the films, for not recording the videos of the space yoga retreat. With this I would like to sum up the rebuttals, Your Honor.
Can you please make for me the conclusion out of everything what you said? Actually, I want to hear pertaining to the point that was raised by the junior claimant pertaining to the breach of the contract. Because out of your submissions, I didn't quite get it.
Uh, Your Honor, the breach of contract is clearly evidenced by the fact that she concealed her medical conditions.
And it
When
breached
there,
what? I mean, like, you're alleging the breach, she is telling that it's not the breach of the contract, and she is providing exact, according to her, the arguments. So I want to hear the arguments why it's not the breach of contract, or why it's a breach of contract, vice versa for you.
Your Honor, while entering into the, bring your attention to clause 5.2 of the agreement, Your Honor. Here it tells that, specifically tells that, to the best of the knowledge of the individual, they must disclose their medical conditions or symptoms which are potential to carry out the space mission. This is the clause in the contract which the both the parties have agreed upon, and in a way it's an obligation of Artricia to, to disclose her medical conditions with regard to this clause. Further in clause 5.2 of the agreement, the passenger also undertakes to promptly inform the space flight operator if there is any change in the medical condition. Firstly, Your Honor, while entering into the contract, it was agreed between the parties that the participants in the space yoga retreat will disclose all their medical conditions, potential medical conditions, which would affect their space travel. And subsequently, it was mentioned that from the duration of the agreement signature to the launch date, if there are any changes in their medical conditions, that too will be intimated to the company uh, by the participants. So
So,
these two.
so this is you alleging that this is the breach of the contract, right? But what your opponent was stating that it's not a breach of the contract because, according to your contract, it was an honest belief rather than to deceive. So that, can you elaborate on this very briefly? Like we're running out of the time. One sentence.
Your Honor, the beliefs or aspirations of the individual cannot justify their breach of contract, is what the council seeks to make, Your Honor.
The
The
council was making another point. That's what I'm trying to
Because
push.
when the person enters into a contract, they must abide by the terms and conditions laid down by that, rather than overriding with their personal beliefs and aspirations.
But according to the contract that you have just cited, it's to the best of their knowledge and belief. And currently, you are telling me that no, like beliefs are not here for anything.
Your Honor, it is clearly mentioned in the Moot proposition that she also believed for the fact that her chronic headache would stop her or would restrain her from participating in the space flight travel, and hence she willfully and mindfully concealed that fact. While she believed that the participating in space travel would cure her headaches, on the other hand, she also believed that not disclosing this matter as to her chronic headaches will also refrain her from participating in the space flight travel. So this clearly evidence that she has willfully concealed the fact in order to give give a way to her beliefs.
Thank you. I just noticed that we just lost our junior claimant, and I would want the senior claimant to ask, where is our junior claimant?
Yes, Your Lordship. Can I
Oh,
continue?
yes, please.
Okay, so the first issue that I would like to address here is that she mentioned, the defendant mentioned that there was no mention about the restoration of a chronic disease, whereas in the para 4, it clearly states that Solar Dreams CEO, Mr. X Delta, who is long-standing yoga and meditation enthusiastic, and it has been heard that in space travel circles that Mr. Delta spent substantial sums employing the world's leading yoga and meditation practitioners to help it design it. But on its website, it clearly mentions that Solar Dream describes this as being a once in a lifetime yogic experience to amidst the stars, and that the participants can draw upon the energies of space and enhance their life force, which basically contributes that. Her thinking of realigning her stars could cure her headache was proved in this. And second point is that her headache was not contagious. So even if she disclosed about her medical condition or she did not, it did not affect the space flight at all. So she it did not affect the early arrival, but what caused this was the gross negligence, because the nurse who was thought that the lateral test was enough, Solar Dream did not take the PCR test into consideration, which is again one of the most important tests, and went ahead without awaiting for the results. They should have awaited for the results to come out, only then they should have proceeded with that. But again, coming to the point that her headache was nowhere to be related with this, the gross negligence of the nurse who thought it was fine to proceed with the space flight without awaiting for the results caused all of this, and the main cause for the early arrival as well. Thank you.
Thank you. Mr. Mohammed, do you have any questions?
No, thank you. I'm fine with this.
So I believe that we need to close this hearing and to thank all the participants for their very hard work, and to say that I don't know which is round for you, but like for the first rounds, it's actually a very good presentation, and at least I see a lot of background work was done, and I'm wishing you all the success in your further rounds, and all the best to everyone.
Thank you.
Thank you.
Yes, I agree with
Thank you.
Anastasia. Thank you for your efforts. I
Thank
see
you.
a lot of efforts has been made. Thank you very much.
Just we will have to talk to Mr. Mohammed in private, please.
Yes, please.
Yeah, just. Or shall we go to the courtroom? I don't know how. Just to go there.
I think no. If they can just leave the room, please.
Yeah. Just do you have a case manager here? Or
Mr. French, I think.
just I don't know who is Afia and Ashna. So like it's Webnyay, right?
No, they are not from Webnyay. I am the only person who is representing from the Webnyay. So I think they are.
Just like to
Afia
confirm
and
that we are just two of us and there are no participants, so we can decide who who will proceed and who will actually win.
Okay, so just let me check.
Yes, please. Because otherwise it will be very embarrassing.
Afia and Asana. So Afia and Asana are the participants from the University of Bolton.
Can you please exclude them just in case?
Okay.
So just all.
So they are not responding, Afia.
But can you just
Miss
push them
Afia.
out? Just like like in Zoom, I believe you can do, or like just to make a courtroom for us so we can talk without anyone.
Asana is there. Afia. So can you guys join the judges room? We have separated room for the judges.
Yeah, but
So you
how?
can join. Yeah, you can join there.
Yeah,
So
but if
should
we
I
can.
join there also? Or like if you guys
No,
have
like
any
we, I believe
difficult.
we're too, we're fine. I mean, just how to join. Can you share the link so we will go there?
Yeah, sure. Just give me a minute. I'll share the link.
Thank you.
Yeah, so I pasted the link in the chat. Can you see?
Yeah.
Yes.
Thank you.
Thank you.
If have any questions or any doubt, any issues, just message me.
Yeah. Okay. Thank you.
Okay, thank you.